Hello, welcome to Tennessee Informer. I'm your host, Dave Vance. Tonight I'll talk about some of the good, bad, and ugly aspects of the key state level races from last week and how it might impact legislation in the future. What can we do to get more voters out, get more informed voters out and motivated at state level races? And some more commentary on what the Supreme Court really said in Marbury versus Madison, and how the distortion of one sentence combined with the misconstruing of the Supremacy Clause has been destructive to our Constitution and our country. I will cover announcements to include some cancellations at the end of the show, so please stay tuned for that. Now for the elections. Very little good news for conservatives in Tennessee. Now, I know that a lot of people are focused just on the presidential election this November, and that they seem to think, way too many people seem to think, that state level races are not important. We had, I don't know if it was an historic low turnout, but we had a very, very low turnout, something like 20%. And, you know, it did vary from race to race. Some were a little bit better than that, but overall, it was not a good turnout. It was not a good night for conservatives for the most part in our state. And so I don't know if it's just everybody stayed home, thought that state level races didn't matter, that the only thing that matters is the election in November, or if they just are okay with what the rhinos are doing, and that the majority of the people that turned out to vote were supporting what the rhinos were doing. I don't know, but I do know that for the most part, the rhinos carried the day. Now, keep in mind, not all campaigns were ran well, and of course, a lot of them are a disadvantage when you come against an incumbent, especially if you're talking about an incumbent with a big war chest, and a lot of them had that. Most of them, all the incumbents had that. And then in some cases, there was a lot of out-of-state money, especially surrounding the voucher issue. Now, if you remember a couple years ago, our state legislature was concerned about what they were calling dark money that was coming from some of the 501c4s, and of course, they were concerned about organizations like Tennessee Stands and to maybe a lesser degree Tennessee Firearms Association, and they were concerned about all that. But I guess we'll see if there's any concern shown by them for all the money that came from out of state for this election cycle, because there was a lot of out of state money. And like I say, of course, you know, the rhinos, hey, they are a herd. They do stick together. They do help each other out. Now, on the Senate side, the only bright spot on the Senate, in the Senate races in our state, was that Bobby Harshberger did defeat longtime incumbent John Lundberg. And it was a you know, decent race, and Bobby Harshberger did win that. I think he'll be good. We'll see. We'll have to keep an eye on him. But, you know, goodbye and good riddance as far as Lundberg is concerned. Now, another race that a lot of people were watching, and I think we're really kind of surprised at, was the race concerning Frank Nicely, Senator Nicely, who we've had on this show here, and a guy named Jesse Seal there in East Tennessee. And, you know, Jesse Seal actually beat him pretty soundly. Now, Senator Nicely doesn't have a great record on illegal immigration, but there's a lot of things that Senator Nicely was very good on that are things, legitimate issues to be concerned about. You know, the whole gold and silver bullion, and the you know, issues having to do with pushing back against the Agenda 21, Agenda 2030, all the globalists. He was well versed on those things, and he did sponsor some good legislation in that regard. So we'll have to see if that's something that Jesse Seal will be interested in picking up on, and will he be any better on the issue of illegal immigration? Now, as I understand it, the governor supported him because apparently he signed on to the whole voucher deal. And that seems to be the governor's main concern is, okay, if you supported the voucher, I'll endorse you, so on and so forth. Now, I think there may have been a few exceptions to that, especially when we get to the House races. But that was his big thing. So Harshbarger is really the only bright spot as far as the Senate races go, in my opinion. One of the big races that everybody was concerned about and really thought we had a good chance of taking was the race between Chris Spencer and Farrell Hale in Senate District 18. And that did not turn out our way at all. Now, granted, they pulled out all the stops. I don't even know, I couldn't tell you what the total amount of dollars are that were spent in that race, but it's an astronomical amount. And I really thought that Chris Spencer had a good chance. And so, and here's the thing, in that race, the word got out. I mean, Farrell Hale had a lot of bad votes. We've talked about him here. You know, he was the guy who sponsored the puberty blocker bill that was basically allowing Vanderbilt to continue to do what they were doing and giving legal sanction to them, giving puberty blockers for children who they were doing surgeries on, children as young as 9. And that got out. Once again, I don't know exactly what their turnout was in that district, but I would have thought that alone would have been enough to get people to the polls and voting against Hale. Not to mention his terrible record on illegal immigration. I mean, he was all for the professional licensing bill. He's been a big supporter. Now, yeah, he's got a couple of votes here lately. This past session, they passed a few things that were supposed to be to deter illegal immigration, but in this current situation, they really don't do a whole lot. I mean, to say that, okay, all the law enforcement has to report every interaction to ICE is fine and well. Doesn't mean anything right now as long as Biden's in office. But when it did mean something, in 2022, when he could have said, I'm not going to vote to make our state more appealing to illegal immigration, I'm going to vote against this professional license bill. No, he voted for it. Yet he was reelected. So I don't know if maybe it looks to me like just mostly the rhinos showed up to vote. Not enough conservatives showed up to vote. Once again, maybe everybody is focusing just on November, but that's no excuse. I mean, state elections are important. The only way to check the federal government is through the states. So you got to elect people in the state that will do that. So we got to find some way to get people motivated and to inform them. A lot of people are like, hey, we need to register, get as many people registered as possible and get them to vote. Well, I only want educated people to, when I say educated, I don't mean degreed. I mean people that know the issues. I don't want more stupid people voting. We've got more than enough stupid people voting already. I mean, you got one whole party dedicated to stupid people voting. That would be the Democrats. And then we have a lot in the Republican Party who back the rhinos who are only marginally smarter than the Democrats. So we don't want necessarily quantity, we want quality. If we can have both, that would be great. Let's finish up the Senate here. I was disappointed, of course, here in District 24. I was hoping, and I knew it was a long shot. I knew it would be a long shot that Charles Cooper could defeat Senator John Stevens, who he did win handily. I will say this, Charlie really had no funding, still got 25%. 25% with very, very little funding. So, and once again, the turnout across the district was really, really low. Stevens, that doesn't change John Stevens' bad record, okay? Now, I guess he sent out enough flyers and said enough of the right things over and over again that enough people believed him. Once again, enough people of the overall low number that came out to vote. So it's disappointing. We've got to get to people some way, somehow, and make them understand that state races are important, that we need to have good people in our state legislature. Now, I'm going to talk here in a few minutes on one of the topics that we talked about last week. Is kind of almost like a part 2 on it, in addition, in reference to the federal government, judicial supremacy, federal supremacy, so on and so forth, and the issue of nullification. But I just to point out how important it is to have people in your state legislature that not only understand and will stand up for you for state issues, meaning your state constitution, and for federal, meaning your U.S. Constitution. If a couple of weeks ago we talked about it on this show, there was not really a debate, but a forum between Charles Cooper and Senator Stevens. And they were asked the question, well, what makes you the most conservative candidate, the constitutional conservative candidate, because both of them claim that title. And Charles gave his answer, and then Senator Stevens gave his answer of, well, I won't vote for, I voted against legislation that the Attorney General said was constitutionally infirm. Therefore, I am the constitutional conservative in this race. Well, okay. He was referencing, without saying, he was referencing the nullification legislation that was sent to summer study. Supposed to have summer study sometime this summer. Still waiting on a date for that. We know it's not going to happen, or that it wouldn't happen until after the election. We don't have a date yet. We are following up on that, and I'll let you know when we find out something about it. So let's go back here. That was a nullification bill sent to summer study. Right before the bill came out, the AG did an opinion on the bill. Now, I'm going to tell you that that's not the norm in this state, that the AG do an opinion on a bill before the bill's been passed. You have a legal section that looks at the bills before they come out and say, okay, yeah, there's no constitutional questions here. Or, hey, this one might be a problem. Well, the AG came out and he called the bill constitutionally infirm. Funny thing is, and we did talk about this on the show because the night before the committee meeting, we had Jeff Gobble on here, the attorney who wrote it, and he was pointing out some problems in the AG's response. Number one, the AG said that it was a violation of separation of powers. Well, certainly not a violation of separation of powers for the governor to give orders to the executive branch to do or not to do something. And in the state of Tennessee, if you look at the state constitution, it's clear that our judiciary in the state does not have original jurisdiction. It only has appellate jurisdiction. And oh, by the way, that can be limited by the legislature, and that's clear as day. So I tend to think that the truth is the AG's opinion is constitutionally infirm. But Senator Stevens thinks that just if the AG said it, he's got to go. And the sad thing is, Senator Stevens is also a lawyer. Now, it gets even better. Remember, and I've talked about this before too, back in 2021 during COVID, when there was a resolution, SJR 9005, that basically telling the federal government in reference to COVID restrictions that, hey, look, guys, we still have some state sovereignty. You can't just tell us anything and force us to do it. And we have the right to nullify. We're not limited just to court action. Our state said that. Now they all have amnesia, including Senator Stevens, acting as if, oh, we can't do this. Or is he saying that he didn't know that it was constitutionally suspect until the AG said something? That's just very hard to believe. Anyway, and he claims to be a fighter. I don't really see a whole lot of fight in somebody who would just say that the AG said it, it must be true. But make no mistake, he and a lot of these others will use anything the AG says to get out of something they don't really want to do anyway. So it's important that we educate the people on the importance of having constitutionally informed legislators who will actually stand up for our constitutional rights. I mean, that is their first responsibility. And overall, they don't do a very good job. Neither at state level or the federal level do they do a very good job. And remember, our state guys, they take an oath to both the Tennessee and the U.S. Constitution. Now, so that was the other Senate. There was another Senate race in East Tennessee, actually two more. Becky Massey defeated Monica Irvine, unfortunately. Senator Gardenhire defeated Ed LeCompte, and it was not even close. So it's concerning that there was a low turnout and that most of these races were not even close. We only pulled one off really that was clearly sending an incumbent home that needed to go home, and that would be the Lundberg race. Now on the House side, the bright spot on the House side, number one, we kept most of our good House members. Unfortunately, we did lose one of the better ones, and that would be John Reagan, and he was better especially in regards to pushing back on a lot of the garbage in our schools. Okay, Representative Reagan wrote a lot of those bills pushing back. And he was one of the more effective legislators as well. So that was a loss. And of course, there was a lot of money in that race thrown against him that he just didn't have enough money to compete. So that's something we'll talk about here in a second. The bright spot on the House side was that Michelle Renaud did send Patsy Hazelwood packet. So I'm looking forward to seeing her up in the House, and I think she will do an excellent job for us. You know, in the state of Tennessee, as far as conservatives go, you know, the Tennessee Firearms Association, although their issue is just firearms, most of the people that they end up supporting and putting in office, you know, most of them, tend to be very conservative and very constitutionally minded on other issues as well. And that pack has grown over the years. But one of the things we're going to have to do in this state, some way, somehow, is have a well-funded pack for conservative candidates across the state. The establishment is loaded, guys. They don't have to go out of state, although that happened this time. The establishment is loaded. And we as conservatives, we don't have a sizable pack in this state that funds true conservatives. You know, we got a few here and there that do a little bit, but we need a sizable pack ran by conservatives to really make a dent and have an effect on the legislature. And I don't know how we go about that, but that's something we have to do. That and educating the people on the importance of voting in state level primaries especially. Now, I want to get to the issue of federal supremacy and Marbury versus Madison. We talked about federal supremacy and we mentioned Marbury versus Madison some in the show last week with Jeff Cobble. Now, this is some additional info that we didn't really cover. And some of it's a refresher. You know, we're going to put some slides up there that are something of a refresher. So I want to kind of hit that, and then I want to go into Marbury versus Madison because we've kind of been sold a bill of goods on that over the years, and so I want to hit that. So delegated federal power. The powers of the federal government are enumerated primarily in Article 1, Section 8 of the Constitution. Powers prohibited to the states are found in Article 1, Section 10 of the Constitution. So Article 1, Section 8 tells you most of the things that the federal government is supposed to do, the main powers, okay? Article 1, Section 10 tells you the things that the states cannot do. Then you have the Supremacy Clause, which is Article 6, Clause 2. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary, notwithstanding. Now, so the Supremacy Clause, it referenced laws in the states, but remember, it's talking about the Constitution here of the United States. That's the law, the powers delegated in Article 1, Section 8. And that's the powers prohibited for the states to take action on. So that's when you read it, you need to read it understanding that. It's not intended to impact all of the other laws in the states unless those laws infringe on the delegated powers to the federal government. Now remember, when the Constitution was passed, we didn't have a Bill of Rights yet. That didn't come until a few years later, but it was passed with the understanding that there would be a Bill of Rights attached, okay? Because there was a lot of concern, especially with certain clauses, the necessary and proper clause, the supremacy clause, the judicial clause, general welfare, interstate, all those clauses were very concerning to the people known as the anti-federalists who were opposing the Constitution because they were afraid it was going to create a federal government that was too powerful, that they were just basically recreating what they just fought against. And they said, okay, we'll support this, but several key states, Virginia and others, we want a Bill of Rights added. Madison agreed to that, so then we got the Bill of Rights. So you already had, before you even get to the Bill of Rights, which includes the 9th and 10th Amendments, you already had an understanding that this was a limited government, not a limitless government, but a limited government, that the powers of the federal government were identified in Article 1, Section 8 primarily, and the things that the states couldn't do were in Article 1, Section 10. That was the agreement. Those were the operating principles for the Constitution. Now, before we talk about the Bill of Rights, remember that one of the arguments, a lot of the Federalists opposed the Bill of Rights, not necessarily because they didn't want the states to maintain those rights or that they were actually opposed to ensuring those rights, but they're like, well, wait a minute. Number one, why make a Bill of Rights for powers that we don't have? And oh, by the way, they're just mere parchment barriers. They're not going to change anything, okay? Because we already don't have the power to do those things. Now, we'll talk a little bit more about the term parchment barriers in a little bit, and that's something that both parties, the ones that agreed and wanted the Bill of Rights and those who opposed it, they did agree about one thing on parchment barriers, and I'll get to that here in a little bit. So then we get to the Bill of Rights, that's added in 1791, and then of course that includes the 9th Amendment, states that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So just because we didn't name it, if it wasn't given to the federal government or prohibited to the states, it's retained by the states or the people. 10th Amendment, the powers not delegated to the United States by the Constitution, nor prohibited by the states are reserved to the states respectively or the people. So what should states do if any branch of the federal government, to include the Supreme Court, usurps power not delegated? Now, obviously my answer to that is nullification, and we'll get to that a little more here in a second. So one of the things, back to the parchment barriers argument, and there is a site that you really, really need to visit if you haven't already, and that's the 10th Amendment Center. There is a lot of information on there. We hear a lot about the Federalist Papers, and the Federalist Papers are great. They were written primarily for the New York audience prior to ratification of the Constitution, but there was another guy, a Federalist, a guy who supported the Constitution as proposed. His name was Tench Coxe, and that's not the Tench is not a very common name, but he was from Pennsylvania, and he wrote something about the Constitution. Actually, by the time he wrote it, Pennsylvania had already passed it, but several other states had not. And they have a lot of information about Tench. Let me make sure I'm pronouncing Tench Coxe. Tench Coxe is his name. It's Tench and then Coxe. He wrote a lot and was read a lot, more widely read than the Federalist Papers were prior to ratification. But if you go to the 10th Amendment website, 10th Amendment Center website, you can get a lot of information on him, and he talks a lot. He does a very good job of explaining the Constitution, and this is even before the Bill of Rights are added. So you already had a limited government even before the Bill of Rights were added. And the purpose of the Bill of Rights was to kind of remove all doubt. All right, that was the intent. Now, so another thing that they mentioned that the Bill of Rights and really the whole Constitution, just because something is written, that doesn't mean everybody's going to follow it the way they should. They talked about that. If you read their letters between each of them, and if you read other things they wrote, they talked about, for instance, Bill of Rights would be, they're just mere parchment barriers. The whole Constitution is a parchment barrier if the people who take the oath to uphold it don't do that. And so, who do you think is most likely to uphold state powers? Who do you? It was made clear if you read the Federalist Papers and if you read things written by other founders, they fully expected the states to step up. This thing wouldn't work otherwise, okay? Just like it's even true today, there's no federal program that operates out there effectively if the states are not supporting it. That's why I say all the garbage we got going on in our country, all of our states are complicit. Every one of them is complicit to some level, all right? Because the federal government can't do these things without support of the states. But back to the parchment barriers. If you don't have people who will say, no, we're not doing this, we're not going to allow you to do it to our people, you can go and you can have another constitutional convention, there are you Article 5 people, and write whatever you want. But if you don't have people at the state level, eventually it's going to be ignored. And the founders knew that. We do put the founders on a pedestal, and they deserve a great pedestal. To a great degree, they deserve it. Now, the founders, obviously, they were all part of the American Revolution, breaking away, seceding, as if you will, from England, all right? And they were all on the same sheet for that. That doesn't mean they were all on the same sheet when it comes to what kind of government they wanted. Now, I don't think any of them, even the ones who wanted a top-down government, I don't even think Hamilton, as much of a monarch as he was, I think he would be shocked at what we allow our federal government to get away with. Things that the federal government pushes on us that we take, that our state helps them push on us, even if our state complains about it. So they always knew that the government would have that tendency, that eventually they would overreach, they would overstep. They expected that. And if you read the Federalist Papers and other documents, they expected the states to step up. So even though, like I say, they deserve credit as the founding generation for both the Revolution and the Constitution they gave us and the Bill of Rights, they set a good example. But they also gave us a good example of what to look out for. Think about it. 1791, we passed the Bill of Rights. Alien and Sedition Acts were in 1798. Adams was president. And we had this thing going between England and France, and here at home, we'd kind of chosen sides. So the Federalists were kind of supporting England. What was known as the people who were supporters of Jefferson, known as the Democrat Republicans, although I don't know if that title was given to them quite that early. They were like, well, hey, France helped us, and they were more supportive of France. So there was some choosing sides there within our country at the time. And so the Alien and Sedition Acts come out. That's put out under the Adams administration. And the alien portion of it was that the president could decide if somebody was a threat, some foreigner was a threat, and he could throw them out on his own. And the sedition part was you couldn't criticize the president or other members of his staff It excluded the vice president, who, by the way, was Jefferson at the time. And they didn't like Jefferson, so they didn't care if you criticized him. It was also scheduled to expire right after the election, okay? Now, so that was the Alien and Sedition Acts. Election of 1800, the Federalists are swept out of power, and then Jefferson takes over. The law is, it becomes moot. It basically ended on election day, so it no longer applied. Right before Adams left office, he made a lot of appointments, judicial appointments. Basically, okay, yeah, we're losing power here, but we want to make sure that we have judges, Federalist judges, who tended to be, we'll say, big government type guys, ones who would support the federal, if there was an issue between the federal government and the state government, would be more inclined to support the federal government, okay? And so they made a lot of these appointments, like just the night before. I mean, he was writing them the night before they were getting delivered. And Jefferson thought, hey, this is garbage. And there were a couple of appointments, commissions to be judges of varying levels that were not delivered on time. And now remember, the name John Marshall, who's a few years down the line, he's the Supreme Court Justice, okay, during the Jefferson administration. But he was Secretary of State for Adams. He was involved with this issuing out of the commissions. There was a guy named William Marbury, got his commission, or wasn't delivered on time. So he sues. Jefferson's like, oh, this is all political. He's not paying much attention. James Madison, as the new Secretary of State, is the one who's being sued by William Marbury. By the time it finally gets there, it's 1803. There's a lawsuit over the commission. Marshall was the Chief Justice, and he's decided looking at the case. Now, he wanted a powerful court. He wanted an activist court. All right, and he was more inclined to federal power, let's put it that way. And he had to make a determination, is this a legitimate case? Was the guy entitled to the commission? Yes, he was, okay? He was denied it, is there a remedy? Yes, there is. The remedy would have been, he would have issued a mandamus to, hey, for them to deliver the commission. But he knew that the Supreme Court, okay, the Supreme Court does not have the power of the sword. It relies on the executive. The Supreme Court does not have the power of the purse. That's with your legislature. That's with your Congress. He knew that he could tell the Jefferson administration, here, you must deliver this, and they could ignore him, and he had no power to do anything. So what he did is he looked at everything, and now this, what I'm telling you, I've read several different sources. One of them is a book written by Robert Bork. If you remember Bork, he was appointed to be Supreme Court Justice during the Reagan administration. And Biden and all the other people in office at the time were just all out against Robert Bork. You ever heard of the term getting borked? That's where that comes from. There was Robert Bork before there was Clarence Thomas and all the garbage they did to him, all the garbage they did to Kavanaugh and others, okay? Bork was the first one, okay, that they really went after. So reading Bork's book, and I've read it other places too. Now, I'm sure there's probably some people that would disagree with this, but the claim is that Marshall distorted the actual law. He made a reference to the law that was the judicial rearrangement, or the Judicial Act, I think, of 1793, I believe it was. He claimed that the federal government, the legislature, exceeded their authority in terms of, in order to deliver the mandamus, basically, hey, you have to do this. He claimed that they distorted their authority. and that the law, and I apologize, this may not be clear what I'm trying to get across. He claimed that they did not have the authority, that they broke the Constitution when they passed that portion of the law. Therefore, even though the commission was a legitimate commission, so to speak, and the guy was entitled to it and entitled to action, since the Congress exceeded their authority in the type of power that they gave between original and appellate that they gave under this act, that was unconstitutional. So he just basically left it at, you guys passed an unconstitutional act. Now, what you always hear them quote from Marbury versus Madison, when he did say this, you always hear this: it is emphatically the province and duty of the judicial department to say what the law is. Those who apply the rule to a particular case must of necessity expound and interpret the rule. If two laws conflict with each other, the court must decide the operation of each. And that's John Marshall, the Chief Justice. Now, obviously, the courts have a purpose, okay? I mean, they do have a purpose. But now, he does not say, he says that it is emphatically the province and duty of the judicial department to say what the law is. That has been interpreted and later interpreted in Aaron v. Cooper in 1958 to mean that, and they reference this case. In 1958, they reference this case, and they say that means that the Supreme Court is the final arbiter of all constitutional questions. Now, you see what he said here, and they make a reference to that a lot. But in the same opinion, they also say, he also says this: the powers of the legislature are defined and limited, and those limits may not be mistaken or forgotten. This is the Constitution is written. To what purpose are powers limited, and to what purpose is the limitation committed to writing, if these limits may at any time be passed by those intended to be restrained? The distinction between a government with limited and unlimited powers is abolished if those limits do not confine the persons whom they are imposed. It's also, if acts prohibited, it is also not entirely unworthy of observation that in declaring what shall be the supreme law of the land, the Constitution itself is first mentioned, and not the laws of the United States generally, but those laws only which shall be made in pursuance thereof have that rank. So remember the Supremacy Clause that they always say, hey, see here, this means all federal laws are supreme. Marshall is refuting that right here. He's absolutely refuting that. Not entirely unworthy of observation that in declaring what shall be the supreme law of the land, the Constitution itself is first mentioned, and not the laws of the United States generally, but those only which shall be made in pursuance of the Constitution have that rank. Thus, the particular phraseology of the Constitution of the United States confirms and strengthens the principle supposed to be essential to all written constitutions, that a law repugnant to the Constitution is void, and that courts, as well as other departments, are bound by that instrument. A law repugnant to the Constitution is void. An act of Congress repugnant to the Constitution of the United States cannot become a law. The Constitution supersedes all other laws, and the individual rights shall be liberally enforced in favor of him. That is a clearly intended and expressly, as the clearly expressly designated beneficiary. That's all from Marbury versus Madison. Okay, so they take that one thing that he says, that it's emphatically the province of the court to say what the law is, and then in 1958, and before then, well, we're the court. We get to say. we get to be the final arbiter. That's not what he said. And if you read everything else, and remember, if you go read, you really should read this case. Now, I will tell you, he beats a dead horse for the first several pages. He could have easily in one page said, okay, was the commission, was it signed? Was everything proper? Was the person entitled to it? Was he qualified and entitled? Yes. And then could have gotten into the meat of the opinion. Because remember, courts only issue opinions, okay? They don't have the power of the purse. They don't have the power of the sword. All the things he said are the same arguments that were made in the Kentucky and Virginia resolutions, and the same arguments that you read other places in the Federalist Papers and in the writings of Tench Coates. They're the same thing. And so it makes it obvious that we're all bound by it, and that the court, if the other departments are bound by it, if the court, and part of really what he was saying is, look, you cannot force us as the court to bless off on something that you did that was unconstitutional. Likewise, the courts cannot force the legislature, the Congress, or the president, for that matter, to bless off on something that's unconstitutional. They all have a responsibility, and they're not all going to understand the Constitution the same way. But the court gives opinions. Now, remember, this is 1803. And there were other cases, and I'll give you a good example. I think we probably used it before. I know it was brought up in the AG's opinion, and it was brought up last Saturday in the debate about what, Jackson, during the Indian Removal Act, Marshall was the Supreme Court Justice, and he ruled that what was being done under the Indian Removal Act, which basically preceded what we know as the Trail of Tears, that was unconstitutional. What did Jackson say? Jackson said, Marshall's issued his opinion, now let him enforce it. That's a reference back to the fact the court doesn't have the power to act. They have the power of opinion. If the executive branch says, I disagree, they don't have any way to make the executive branch do it, unless the executive branch just feels like, well, yeah, they're right, and everybody knows they're right, everybody believes they're right, I probably should go along with it. They don't have the power to make him do it. And forget this co-equal branch garbage. The Supreme Court cannot impeach anybody in Congress. The Supreme Court can't get rid of the president. Now, the Chief Justice oversees an impeachment trial, but he just oversees it. He's not making the decision. The Congress has the power of impeachment. They have the power of removal. They have the power of the purse. They can remove the president. The court has the power of opinion. That's what they have. And we've allowed all these people who want a strong judiciary and want a top-down federal government to just say, well, look, this is our system. We have to do whatever the judges say. And that's just garbage. That's not the way it is. There's been other cases where the courts have been ignored because, once again, they issue opinions. They don't issue, edicts. And the president and the Congress, they have the right and the responsibility. And oh, by the way, the president and Congress, but guess who else has the right and the responsibility when the Supreme Court or any branch of the federal government attempts to exceed the Constitution? The states have the right and the responsibility to say, no, we are not cooperating, and we're not going to allow you to do that in our state. Now, that does not revoke the law, but it nullifies the law. It makes it of no effect in their state. Obviously, the hope is that other states will do the same thing. Several states do the same thing on a certain issue. D.C. gets the word, and they're like, yeah, okay, this is not working. A lot of times you'll hear too, I want to hit something about Madison, because Madison wrote the Virginia Resolution, and Jefferson wrote the Kentucky Resolution. Now, that was written 1898, still under Federalist control, all right? Your Congress was primarily Federalist. A lot of your state governments were Federalist. Just Virginia and Kentucky passed these resolutions, and a lot is made of the fact that other states did not join them, and even some states even rebuked them for it and says, you got to do whatever the court says. Well, keep in mind, the Federalists were the ruling party at the time. Guys, they had party politics even then. Even if the names weren't necessarily, they had a team, okay? There was two different teams there, two different outlooks. And so, yes, it's true. Other states did not join them. Some other states condemned them for that. But guess what? Some of those same states, a few years later, when Jefferson was in office and did some things that they felt was that he was exceeding his power, guess what they referred back to? They referred back to Kentucky and Virginia resolutions. And they used nullification. Now, another thing about nullification, you'll always hear, well, it's been tried before, it never works. And they'll bring up the situation in the 1830s, although there were issues in Northeast prior to that. In the 1830s, you had the whole thing with South Carolina and the tariff. And I think we did talk about this some. First off, do not let them tell you that all nullifications are the same. What South Carolina was trying to do, number one, they were saying that the tariffs, the unfair tariffs, were a violation of the General Welfare Clause. Well, whatever your opinion may be of the accuracy of that, the Constitution still allowed, it definitely allowed these tariffs, all right? And then the whole idea put forth by them of how nullification, how if one state nullified, the whole Constitution was nullified, that one state can nullify it for everybody, for every other state. That's what Madison objected to. He did not renounce the concept of nullification. All right, so that's another thing they'll throw out there at you. I want to throw you a couple things here too, some other cases after this, and this is justification for nullification. An unconstitutional law is void and is no law. An offense created by it is not a crime. A conviction under it is not merely erroneous, but is illegal and void and cannot be used as a legal cause of imprisonment. Ex parte versus Siebold, 1879. Actually, I think that one was a little bit earlier than that. And then there's another one. Unconstitutional law is not a law. It confers no rights, imposes no duties, affords no protection. It creates no office. It is legal complementation, is inoperative as though it had never been passed. That's Norton versus Shelby, 1886. And there's a good article in the 10th Amendment Center on the myth of Marbury versus Madison. And it will explain it a whole lot better than I did. It was written by one of the authors there that I can't recall his name, but he was basically giving you a breakdown of an article written by a professor in the early 2000s out of Wisconsin. And so, you know, guys, it's not just a few people like myself and others in the state here that think that nullification is legitimate and that think our federal government, our judiciary is out of control. There's been people throughout our history, and there's people now. But the bottom line is it takes people to step up. The voters have to demand it of their elected officials at the state level. Well, they're not going to demand something they don't understand. But that's why it's important to learn it, understand it, and be able to make them understand it. And I know I haven't done the greatest job getting this across tonight, but I hope you understand that we've been sold a bill of goods. And I don't care. I understand we're in the minority right now. I've got that. 98% of your lawyers are wed to this fact of judicial and federal supremacy. Guys, it makes no sense. It makes the rest of the Constitution and any guarantee of your rights moot. They can't mean anything. You don't have rights, you have privileges waiting to be revoked if federal and judicial supremacy is what they tell us it is. But Marbury versus Madison, who they quote, and I really do encourage you to go read the decision. You can read the first few minutes and you'll understand the case. And then if you get down to Marshall's reasoning for his opinion, that's the meat of it. And that's where you'll read all those things, and you'll think that you're reading a pro-nullification document. You'll think that you're reading a state's sovereignty document. The only thing that will be a little different is that it's where he says it's the judiciary's responsibility, but he doesn't say that they are the final arbiter. And if you read the whole thing, you'll understand we're bound by the Constitution. And oh, by the way, remember, that Constitution is laid out. The powers are laid out. Article 1, Section 8 primarily. Article 1, Section 10, things states can't do. And just to remove any doubt, look at the Bill of Rights, especially the 9th and 10th Amendments. So if you read those, look at that, to come away with this idea that they gave us a federal government that was supposed to make the decision on everything, and oh, by the way, that it would be the court to make the decision, makes no sense. And if you read the ratification, really that's another thing you need. Read the ratification debates of the states. Read Virginia's. Read New York's. Read them all. A lot of them included statements about their understanding. And oh, by the way, if it doesn't work out this way, we'll leave. Okay? So, educate yourself, get other people educated. 10th Amendment Center. And hey, look, Tennessee Citizens for State Sovereignty. We have their link on our site. We have good articles on our site and other resources on that site to include, and this is a really good one, the night before the bill was presented back in March, we have Jeff Cobble on here. And like I say, I think he pretty much destroys the AG's constitutionally infirm opinion. It's worth listening to. Now, we are working on something on that. And also, the debate from last week between Jeff Cobble and Mark Pulliam, it was a 2-hour debate, recorded in Lebanon. That will be posted on the site very soon, okay? And I believe there's going to be another talk that Jeff gave this past weekend. That will be eventually on our site if it's not already. So that's pretty much it for tonight. I've got a few announcements here. Matter of fact, there's one that I forgot to actually list on the slide, so I'll read it to you. And this is the Montgomery for Liberty upcoming meeting, Tuesday, this is Montgomery County, Tuesday, August 13th, 6:30 p.m. at Tap House 57. That's at 2670 Madison Street, Unit C. So this is the new liberty-oriented organization in Montgomery County, which is Clarksville primarily. And they're going to have this, I think, is their second meeting. So Montgomery for Liberty, upcoming meeting, Tuesday, August 13th, 6:30 p.m., Tap House 57 at 2670 Madison Street. And next time I'll have the slide up. I apologize. Also, the Stewart County GOP fundraiser schedule for August 10th has been canceled. We will notify the public when the event is rescheduled. The Henry and Stewart County TFA will meet this Thursday. TFA is Tennessee Firearms Association. This Thursday, August 8th, 7 p.m. at the Holly Fork Shooting Complex on Highway 79 in Paris. An officer from the Henry County Sheriff's Office will discuss active shooter response. You do not have to be a member to attend. I want to thank you all for taking the time to watch our program tonight. Please be sure to hit the like and subscribe buttons as well as the notification bell so that you never miss an episode. It really goes a long way to keep us on the air. Check out our audio podcast on iHeartRadio, Spotify, and other platforms. Sign up for our weekly newsletter at website tninformer.com. Our guest next Monday night will be Kathy Henners, here to give us an updated status on the Islamic activity in Tennessee. Now, if you're paying attention to what's going on over in Britain, where they've had a problem with illegal immigration because their federal government is leading the invasion of their country as well, as are most countries in Europe, most governments in Europe. And of course, they have gotten a lot of Muslims over the years. We've got more than enough here, and they are an issue in Tennessee. But it has reached the tipping point there. And now you have the natives who are fed up with what their government is throwing on, and now it's broken out. They're talking civil war. Guys, we may end up in you think about it, our border is wide open. Look at our government. You think our government cares any more about us than Britain's government cares about them? No, they obviously don't. So pay attention to what's going on over there. Please tune in next week. Kathy Henners knows a lot about the Islamist group that are in Tennessee, and we're thick with them in Tennessee. I mean, you remember we had the Chattanooga shooting several years ago. We had the Carlos Bledsoe. We've got organizations, you get there, the compound in Dover. We've got some bad actors in this state, okay? And Islam is not here just to be another religion. You need to go read what their doctrine is. They are a problem. You need to know about them. Because guess what? You trust our government to inform you? Our government is untrustworthy. You got to learn and educate yourself so you know what to look out for. Hope you'll join us. That's it for now. Good night from Paris, Tennessee, that is.